Hello guys, I hope you're well and welcome to the Global Legal Reflector channel. In today's video, we are looking at the court process in civil cases, and we shall be focusing on the entire court process right from the beginning to the very end of it. We shall also be focusing on those tricky aspects of the case which must be handled keenly so as to avoid messing up the case. The very first thing that you need to do even before considering moving to court is to collect all the evidence and identify any potential witnesses that you may have. When it comes to evidence, remember that this could take various forms. It could be in form of documents or even photographs. It could even be phone conversation, text messages, or even videos. It can even go as far as being social media posts. Just ensure that you have any of these materials which are important to your particular case. Also, when it comes to witnesses, ensure that you get in touch with anyone that you think can be of help to your case and find out whether they'll be willing to come and testify if you move to court. The second aspect of the process is the pre-court engagement, and this usually starts with the demand letter. You have to do a demand letter to the opponent, then wait for their response. And when they respond, you can then go through their response and see whether there is any need for you to do a reply to that response. If there is no need for the reply, then this allows you to move to the next step, which is going to court. But if the response that they have actually served you is in such a manner that opens the room for negotiation, then it's important that you pursue that avenue, because it could be one of the important things that allows you to have the claim settled even before going to court, and this will save you so much time. And before we move to the next part, I want to let you know that a demand letter is very important, because if you fail to write a demand letter, then that will be detrimental, because you won't be allowed to claim for the costs of the case even when you end up winning the case. The third aspect of the process is the choice of court to approach, and this is usually determined by the following components. The first component is the geographical jurisdiction, and by this we mean the location where your claim has arisen. You have to ensure that you have your eyes set on the court that has the geographical jurisdiction, and that means the court is within the same location, the same locality as where your claim has arisen, so that there cannot be any objection when you finally file your case in that particular court. The second thing is the pecuniary jurisdiction, and by this we mean the monetary value of the claim which that particular court is able to entertain. You have to ensure that the court you are approaching is actually mandated to entertain a claim of that particular value. For instance, in Kenya, there is the Magistrates Court and the High Court, and the claim that a magistrate court can entertain is from 0 shillings to a maximum of 20 million Kenyan shillings. If you have any claim that is above 20 million Kenyan shillings, that means you have to go to the next forum, which is the High Court. So ensure that you have the right court in terms of monetary jurisdiction. And there is still another thing that you have to consider, and that is the various divisions within a particular court session. This is a rare thing, but it sometimes matters a lot. For instance, in Kenya, we have the Milimani Law Courts, and to be specific, the High Court, which has several subdivisions. Like, for instance, we have the Civil Division, the Commercial Division, the Family Division. the constitutional and the constitutional division, and there is also the judicial review division. You have to ensure that you are approaching the right division even within that particular station. The fourth aspect of the process is drafting of court documents. And drafting is usually done once you have identified the nature of the case and have also identified the court to approach. Now, when it comes to drafting itself, there are various documents that can be drafted and used for starting a case. But the most common one, and the one that we shall be focusing on in this particular video, it is the plaint. And when you draft the plaint, it is normally accompanied by a set of other documents, and these usually include the verifying affidavit, the list of witnesses, the witness statements, the list of documents, and the bundle of documents that you shall be relying on. The fifth aspect is filing of the case, and this is usually done at the registry of the respective court station that you have chosen to present your case to. And when you go to do the filing, you first of all begin by presenting your set of documents to the registry assistant. The registry assistant will inspect your documents, and upon inspecting them, he or she will assess for you the case filing fees. Now, the case filing fees usually vary from case to case. And when the assessment is done, you are required to pay the fees. And when you do the payment, you will be given a case number that is unique for your particular case. Your documents will also be stamped at this point as a confirmation that you have filed them and you have paid the requisite court filing fees. Now, during this digital era that we are in, the filing system has also taken another angle. We have filing being done online, and that means you don't have the traditional way of presenting the documents at the registry and having them stamped. The filing is being done by uploading the documents in the e-filing portals, and when you do this, it means that you won't be given the ordinary receipt that comes with the traditional filing, but in this particular instance, you will have what we call the electronically generated receipt, which will serve as the proof for your payment and for the filing of your particular case. The sixth aspect of the process is what we call activities after filing of the case. And these activities start with extraction of a document that we call summons to enter appearance. Once your case has been filed, you have to ensure that this document that is called summons to enter appearance has been prepared by the respective registry. Then that document has to be signed and stamped by the judicial officer to have the document carry legal power. Now, when this is done, you are required to immediately serve this document called the summons to enter appearance together with all the other documents that you have filed upon the defendant. Now, when the defendant receives these documents, they normally have 15 days. That is in Kenya. This could vary in other jurisdictions that you may be in, but here in Kenya they will have 15 days to enter appearance in their suit. Entering appearance implies that they have filed their memorandum of appearance and they have acknowledged that there is an existing suit against them and they are ready to defend it. And once the defendant enters appearance, they will again have another leave of 14 days from the date on which they enter appearance. They will have these 14 days within which to file a defense in the case. Again, this could vary depending on the jurisdiction that you are in. But in Kenya, the maximum number is 14 days. Failure for a defendant to enter appearance will entitle you as the claimant and as the plaintiff to actually seek what is called judgment in default of appearance at this level. And that is very possible if they fail to do what is required of them, fail to actually enter appearance within the 15 days, then you can request that the court grants you judgment in default of appearance. The seventh aspect of the process is the pretrial conference. And the pretrial conference is usually conducted immediately after the close of pleadings. And by close of pleadings, we mean that period where the time within which the parties are required to file their documents has ended. That is now what is called the close of pleadings. The pretrial conference itself is normally conducted as a preparation for the hearing, and it is overseen by the judicial officer. And during this conference, both parties are required to confirm that they have filed all the documents required of them. And not only that, but they have also gone to the point of exchanging those documents. Also, during the conference, the parties are required to indicate whether they'll be calling any witnesses, and if so, how many in number. And amongst those witnesses they'll be calling, is there any expert witness, or are they all ordinary witnesses? That has to come out very clearly during the pretrial conference. Also, if a party would be requiring an adverse party to produce any additional document or any additional set of evidence moving forward as they go into the hearing, they are supposed to make the application to the court at this particular level. Then the court will make a determination on the same, on whether they will allow the other party to produce that particular piece of evidence, or whether they will dismiss that particular application. The eighth aspect of the process is the hearing, and hearing usually involves examination of witnesses. And when this happens, the process requires that the plaintiff goes first. So the plaintiff will be the one that calls their witnesses first, starting from the very first one to the last one, depending on the number of witnesses that the plaintiff has. And once the plaintiff is done with their witnesses, then the defendant will do the same again from the first one to the last one. And when it comes to the hearing itself, this usually has 3 stages. The first stage is what is called examination in chief, and that is where the witness just give their story, what they understand about the case, what happened, who did what, and how it all happened. Then there is the second level of the process, which is now what we call cross-examination. And this is where the opponent or the adverse party questions this particular witness. They question them on various aspects of what they have testified before the court, and the aim of that is to try and actually destroy the evidence given by this particular witness, or to make sure that the evidence of that witness loses its credibility. So that is what is done during the cross-examination. And the last bit of the process is what we call re-examination. And this is now where the party or the advocate to that witness who was testifying comes back after the witness has been cross-examined by the adverse party. The advocate comes back and they ask those questions that are corrective in nature, trying to actually address those wounds that have been left open after the adverse party has cross-examined the witness, to ensure that they again place their case in the right perspective. So that is the main aim of the cross-examination, and that marks the end of the 3 bits of the hearing process. The ninth aspect of the process is close of the case, and this comes when the witnesses of both the plaintiff and the defendant have testified. Once the witnesses of the plaintiff are done testifying, the plaintiff will usually ask the court to mark their case as closed. This will also be the same thing for the defendant. Once their witnesses have testified, they will ask the court to mark their case as closed. And when this is done for both parties, then this allows the court to move to the next step, which is now the part of what we call submissions, or the skeletal arguments. The court will ask both parties to file their submissions or skeletal arguments within a particular period. This is within the court's discretion. It can decide on the number of days that it will grant to each party. And in these submissions or the skeleton arguments, the parties will be advancing their various arguments on how the facts presented during the hearing and the various provisions of the law support their chosen position in the case. They will be trying to actually convince the court to rule in their favor in the final determination. The 10th and final aspect of the process is the judgment. And when it comes to the judgment, the court will have considered all the documents filed by both parties, the evidence that came out during the hearing, and all the arguments advanced by the parties in their respective submissions or skeleton arguments. And when this is done, the court now comes to a conclusion, and that conclusion is what we are calling the judgment. And the judgment is usually read out in the open court in the presence of both parties. And when this judgment is read out, there is one side that wins the case and there is the other side that loses the case. In Kenya, the law allows a losing side to appeal the case if they so wish. And if the judgment was from a magistrate's court, the losing side will have 30 days within which to file an appeal to the High Court. But if the judgment was from a High Court, then the law allows the losing side to appeal the decision to the Court of Appeal within 14 days. Again, this number of days could vary depending on the jurisdiction that you are in. And that being said, this brings us to the end of the court process in civil cases. If you find this video helpful, please remember to subscribe to the channel and to turn on the bell icon so that you can be notified whenever we put up any other informative video. Thank you and see you in our next video.